La Cour. Please be seated. I declare this hearing open. This morning, I will deliver Advisory Opinion P16-2025 number 1, pursuant to Article 4 of Protocol 16 to the European Convention on Human Rights and Rule 94 of the Rules of the Court. This opinion is delivered at the request of the Ukrainian Supreme Court. That court has been duly notified of the delivery of the opinion today, as have the parties to the domestic proceedings. Likewise, the government of Ukraine has been informed of today's delivery and is represented here this morning by Mr. Skuratovsky, Deputy Permanent Representative of Ukraine to the Council of Europe. I welcome him in the name of the Court. The Supreme Court lodged its request on the 21st of August 2025. On the 15th of September, the request was accepted by the panel of the Grand Chamber under Article 2, Protocol 16. The parties to the domestic proceedings were invited to make written submissions, and they did so. The third-party intervention was also made. The request was examined by the Grand Chamber of the Court, which deliberated on the 4th of February 2026. It adopted the advisory opinion on that date. I shall now provide a brief explanation of the background to the request, which is not part of the advisory opinion. The Supreme Court has sought the guidance of this court in relation to proceedings before it. These involve a monastery of the Ukrainian Greek Catholic Church and a former nun who is referred to in the opinion by the initial F. In 2004, F entered the enclosed convent that was attached to the monastery. She took her religious vows in 2009 and remained as a nun in the convent until 2017. She then left due to conflict within the community. Later, F tried several times to return to the premises but was unable to gain access. In 2020, her status as a nun was formally revoked. A new religious community was set up in the convent in that same year. F brought a claim before Ukrainian courts seeking to be granted access to her former cell. The lower courts granted the order sought. They considered that the cell was a home within the meaning of Article 8 of the Convention, and that a right to respect for that home should prevail over the interest of the monastery. The monastery has brought a cassation appeal before the Supreme Court. It argues that the subject matter of the dispute is exclusively governed by canon law and that the civil courts do not have jurisdiction. In its request, the Supreme Court has explained that the case before it concerns the rights for respect to one's home as well as the right of access to court. It also concerns the balance to be struck between those rights and the rights of a religious organization. The proceedings therefore concern Article 6, 8, and 9 of the Convention and raise an issue of principle in which the Court's guidance is required. The Supreme Court put two questions, and I quote. First question, do the premises of religious buildings, monasteries, monastic cells, constitute a home within the meaning of Article 8 of the Convention? Second question, does the National Court's jurisdiction extend to disputes concerning the right of a former nun to use the premises of a monastery where such right arose from an oral agreement with the monastery based on its purpose and the nun's admission thereto, but was terminated as a result of the nun leaving the disputed premises due to a conflict and differences of opinion with the leaders of the religious organization. In reply to the first question, the opinion gives guidance on how to apply, in the specific context of the case, the notion of a home as that term has been interpreted in the court's case law. It affirms that the decisive issue is that of the existence of sufficient and continuous links to the premises in question. In reply to the second question, the opinion clarifies that the key issue is whether Article 6 of the Convention applies to the domestic proceedings. The opinion also clarifies that this issue is distinct from the question of the applicability of Article 8, even if it is found that the monastic cell still represents F's home, the applicability of Article 6 remains a separate matter. I will now read the replies that the Court has given unanimously to the questions posed. First point. The premises of a monastery or convent, including monastic cells, can be considered the home within the meaning of Article 8 of the Convention, read in the light of Article 9, of persons having sufficient and continuous links to those premises. If those links are solely based on religious grounds, then the status of those persons within the relevant religious community occupying the premises becomes particularly important. Point 2. The applicability of Article 6 of the Convention and thus of the right of access to a court guaranteed by it to proceedings before a domestic court depends on whether the dispute concerns a right which can be said, at least on arguable grounds, to be recognized in the domestic law. That is primarily a matter for the national courts to resolve. In so doing, it should subject the claim, as asserted before it, to careful examination and provide cogent reasoning for the conclusion reached on this issue, having regard to the relevant domestic law and case law. In the case that is pending before the requesting court, the domestic provisions and case law concerning the autonomy of religious organizations will be of particular relevance to this assessment. If the National Court concludes that, given the facts of the case and the relevant domestic law, the plaintiff in the proceedings cannot now claim any right, even on an arguable basis, in relation to the cell that she previously occupied, it will follow that it is not required under Article 6 of the Convention to determine the merits of that claim. If, however, the National Court's conclusion that the right claimed by the plaintiff is at least arguable and that the other conditions for applicability of Article 6 are also met, then she would, in principle, be entitled to a determination of her claim in compliance with the requirements of a first civil trial, which have been set out in the court's case law under that provision. Following this hearing, the full text of the advisory opinion in English and in French will be published on the court's website and will be available in the HUDOC database. There will also be available a legal summary and a press release prepared by the court's registry. This morning's public hearing has now reached its conclusion, and I declare it closed.